The law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to today's Law of Self-Defense ongoing coverage of the Kyle Rittenhouse trial. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Today, the trial finally got off to the races with the jury hearing the opening statements of both the state and the defense, and the jury also heard their first witness testimony in the case from the state's initial 3 witnesses. The first witness was Dominic Black, the friend who purchased Kyle his rifle and who was present in Kenosha with Kyle on the night of August 25th, 2020, and who was facing his own criminal prosecution at the hands of Assistant DA Binger, prosecutor in this Rittenhouse trial. The second witness was FBI Special Agent Brandon Crayman, who testified about overhead video taken from aerial surveillance. Unfortunately, for unstated reasons, the court declined to broadcast the testimony of Special Agent Crayman. The third and final witness of the day was Corey Washington, also known as Corey Elijah, reported as a social media influencer who was on the scene during the events of this case. This was only a partial witness today who will continue tomorrow. So even before the jury was brought into the courtroom this morning, however, the defense had a jury instruction issue to raise with Judge Schroeder. Specifically, there always exists some intellectual tension between the legal concepts of justified self-defense on the one hand and allegations of recklessness on the other, and a somewhat odd wording of the Wisconsin jury instructions on recklessness don't help clarify this tension. So recklessness involves the creation of an unjustified and unreasonable risk of death and disregarding that risk in one's conduct. Self-defense, of course, often creates a risk of death, but ought not be considered inherently reckless. At the same time, self-defense is required to be reasonable, and recklessness is inherently unreasonable. Under most circumstances, one won't find an overlap between the legal doctrines of self-defense and recklessness, and so this tension is normally purely theoretical. The Wisconsin jury instructions, in effect, read that self-defense is not a legal defense to an act of recklessness, which makes sense. They also read that an act of lawful self-defense is itself not recklessness, which also makes sense. But what happens when you have self-defense and recklessness simultaneously? Here, of course, we have Rittenhouse raising the legal defense of self-defense to justify his intentional shooting of Joseph Rosenbaum. The state, however, is arguing that not only did Rittenhouse shoot Rosenbaum, to which self-defense is an admittedly permissible defense, but that his conduct in doing so also recklessly endangered reporter Richard McGinnis, who was standing some distance behind Rosenbaum, and self-defense is not a defense to recklessness. This morning, the defense, through attorney Corey Chirafisi, sought to have Judge Schroeder agree that if the shooting of Rosenbaum was deemed to be lawful self-defense, the jury should be instructed that this necessarily meant that this same reasonable conduct in self-defense could not also be the basis for a finding of recklessness with respect to McGinnis. Now, I don't blame defense counsel for making this argument, and the specific and somewhat ambiguous wording of the Wisconsin jury instruction on reckless endangerment surely gives the argument some legs. The normal practice, however, is to analyze the two victims separately, and it must be admitted there are circumstances in which self-defense could be simultaneously reasonable with respect to one party and reckless with respect to another. For example, imagine a scenario where a defender is being charged by a machete-wielding maniac, such that the defender is facing an imminent unlawful threat of deadly force. That justifies the defender in pulling his pistol and shooting the attacker, using deadly defensive force to stop that unlawful attack. But imagine if in the process of doing so, the defender doesn't make any attempt to aim the weapon. Instead, the defender closes their eyes tightly, waves the gun in the general direction of the attacker, and empties the magazine in a continuous flurry of gunshots. And one of those gunshots hits a group of schoolchildren downrange of the attacker, killing a child. It's quite possible that such a use of force against the attacker would be entirely legally justified, and simultaneously that the death of the child is deemed the result of reckless conduct by the defender. And ultimately, that was the position of Judge Schroeder here. There also remain some additional jury instruction questions not yet resolved as of this morning. The first is with respect to count 6 in the criminal charge, which is weapons possession charge, a misdemeanor offense. My own reading of the convoluted statutory structure for this offense is that it's inapplicable to the facts of this case, that Kyle's circumstances exempt him from application of the weapons statute in question. That's also the defense position in the case. The state naturally disagrees. The problem is that Judge Schroeder has yet to decide on how to settle this dispute. And until it is settled, one cannot know how to instruct the jury on the gun charge, assuming the charge ought not be dismissed outright, as I and the defense believe. Frankly, it's extremely disappointing that Schroeder has not decided this matter by this point in the case, with opening statements occurring today, but he has not. Because he hasn't, he ultimately decided to just not really give the jury an instruction on this charge today, meaning the jury won't really understand what to look for in the evidence presented to it on this charge over the course of the trial. It's really just sloppy court procedure. A final jury instruction issue is with respect to count 7 of the criminal complaint, which is the violation of curfew offense. This isn't even really a crime at all. It's merely a civil violation punishable only by a ticket. And because it's so minor, there exists no jury instruction for it at all. So Judge Schroeder will ultimately have to craft an instruction for this jury, and he has not done so yet. Now, once more then, the jury was not given an instruction on that curfew count today. Again, just poor show. But all of that discussion naturally happened before the jury was brought into the courtroom. But with those issues now addressed, or not addressed yet, as may be, the court finally had the jury brought in. At this point, the judge reminded the jury of the charges with some specificity and then read them the relevant jury instruction language for each count, with the exceptions, as already noted, for count 6 on the weapons charge and count 7 on the curfew offense. And the purpose of exposing the jury to the instructions early on, before even hearing opening statements, is that it primes the jury for what to look for as the testimony and other evidence is presented to them in court. The judge also provided some guiding jury instructions on matters like how to evaluate the credibility of evidence, to base the verdict on only the evidence and arguments made in the courtroom, consistent with the application of the law as instructed by the judge, that the defendant is presumed innocent, that the state has the burden of proof beyond a reasonable doubt, the meaning of reasonable doubt, and all those usual kind of operating system instructions for a jury in a criminal trial. Then we finally got to the opening statements. Assistant District Attorney Binger, the lead prosecutor on this case, presented the state's opening argument, and as I'd rather expected and is typical in politically motivated prosecutions of this type, Binger's opening statement was heavy on innuendo, emotive phrases intended to stir fear and emotion in the jurors, and suggestions of poor judgment on the part of Kyle Rittenhouse, but very light on any evidence that was actually inconsistent with Kyle's legal defense of self-defense. Binger made repeated references to Kyle as having shot unarmed victims using an AR-15 style semi-automatic rifle with 30 rounds in the magazine, after which Kyle didn't even stay to care for those he'd shot, but simply walked away. Property is not worth more than life, Binger reminded the jurors, as if Kyle had shot anybody over a mere property offense. Of particular importance to Binger was an oft-repeated theme that despite there being hundreds of people present that night in Kenosha, the only person who shot anybody was this defendant, Kyle Rittenhouse. As if what other people were experiencing or doing has anything, whatever, to do with whether Kyle himself was facing an unlawful, imminent deadly force threat when he fired his rifle. One might as well note that Binger himself and defense counsel Richards and Judge Schroeder, they also didn't shoot anybody in Kenosha that night. So what? There was a lot of innuendo suggesting that Kyle was placing himself in dangerous circumstances unnecessarily. He could have just been home that night. Of course, the same could be said of, for example, Rosenbaum. And Binger tried to head off that avenue of argument by noting that, well, Rosenbaum had been at his girlfriend's house in Kenosha and only ended up downtown because he wasn't able to stay at her house. This line would almost come back to bite Binger very badly later. I'll circle back to this. Binger also made an effort to minimize the possible threat that Rosenbaum could have presented. He was only 5'3" and 150 pounds, for example. Although if his mission was to seize Kyle's rifle and use it to kill him, as he threatened to do only minutes earlier, his size wouldn't seem to matter all that much. Binger also noted that Rosenbaum had only just been released from a hospital earlier in the day, and indeed the plastic bag he was carrying was of the type provided by hospitals for keeping one's personal effects. This line would also almost come back to bite Binger badly later. Binger also introduced the topic of the late-released FBI video footage taken by aircraft over the scene, suggesting that it was Kyle who chased down Rosenbaum, and that it was Kyle who was the initial provoker of the confrontation between the two men rather than the reverse. Binger made much of the fact that Rosenbaum was shot 4 times, once in the back, a point that's technically true, but which is readily explained by the physical dynamics of the attack upon Kyle by Rosenbaum, as the defense would point out in its own opening statement. As for the attacks by others on Rittenhouse as he ran from the site of the shooting of Rosenbaum to the police line down the street, during which he was pursued and attacked, and where he shot Huber and Grosskreutz, as well as firing at the unknown male, Binger put this all down as Kyle's fault, because those other people, purportedly, reasonably perceived Kyle to be an active shooter who they wanted to stop. And that was about it for Binger's roughly 35-minute opening statement. At that point, the court took a brief recess in preparation for the defense opening statement, and when they came back into session, however, it was not to jump directly into the defense opening statement, which would be presented by attorney Mark Richards, because Prosecutor Binger was in a bit of a twist, and he had objections to raise with Judge Schroeder. Binger had discovered to his dismay that Richards planned to use a bucket full of exhibits in the form of photos and videos of the events in presenting the defense opening statement to the jury. Binger himself had used no exhibits to buttress his opening, who knows why, and now he realized that Richards' use of these exhibits would make the defense opening appear much more concrete and evidence-based than had the state's opening, rich in innuendo and suggestions, but light in facts, inconsistent with lawful self-defense. And Binger was quite correct to be concerned, because that's precisely what happened. In any case, basically Binger's argument was that it's not fair, Your Honor. I didn't do any of that. I didn't use any exhibits, so Mark ought not be allowed to do any of that either. It will be too time-consuming. We don't even know if all the exhibits are relevant, although they'd all been stipulated to as authentic. So Judge Schroeder had Richards quickly step through all the exhibits he planned to show the jury during his opening, and there were a great many of them, around 40, which is a lot. Ultimately, Schroeder found none of them objectionable for use in the opening statement. He did caution Richards that the opening statement was supposed to be relatively concise, and Richards assured the judge that he didn't expect to take much longer than had the state's opening, and he was true to his word, taking about 40 minutes compared to the state's 35 minutes. But that wasn't Binger's only complaint. Binger was apparently also in a twist because he'd learned that the defense planned to introduce 2 facts into evidence during their opening statement that he'd reasonably expected not to be admissible. The first of these facts was that on the night of August 25th, Rosenbaum was under a restraining order from his girlfriend and facing criminal charges stemming from domestic violence in that relationship. The second fact was that Rosenbaum had just that day been released from psychiatric care in a hospital. Now, these 2 facts normally would not be admissible, so why was the defense planning to introduce both of these facts in its opening statement? Because the defense argued Prosecutor Binger himself had opened the door to the admission of both facts. The door to the restraining order fact was opened by Binger, the defense argued, when he told the jury that the reason Rosenbaum was reasonably downtown, when it was unreasonable, according to the state, for Rittenhouse to be there, was because Rosenbaum had been unable to stay at his girlfriend's house. Well, now the defense wanted to admit into evidence the reason he was unable to stay, the restraining order. The door to the psychiatric release that day was opened by Binger, the defense argued, when the state tried to explain away Rosenbaum's plastic bag and perhaps garner jury sympathy for Rosenbaum and have him appear less threatening by telling the jury he'd just been released from the hospital that day. Now the defense wanted the jury to know the nature of that hospital stay to have been psychiatric, as relevant to Rosenbaum's erratic behavior that evening. Fortunately for Binger, Judge Schroeder was sympathetic to the argument that the door had not been sufficiently opened and the evidence was not sufficiently relevant, that it ought to be included by the defense in opening statements, but the judge conceded he'd be willing to hear argument on the issues later in the trial. The bottom line is that neither fact was mentioned by Richards during his opening, and that's just good luck for Binger. Now, that finally brings us to Attorney Richards presenting the defense opening statement. As already noted, the defense opening by Richards was profoundly more fact and evidence-based than had been the state's opening and was heavily buttressed by some 40 exhibits in the form of photos and videos. Despite all these supporting exhibits, Richards' opening was only about 5 minutes longer than had been the state's. Richards started by reading the jury instruction on self-defense, noting that the use of deadly defensive force was lawful if necessary to stop a reasonably perceived imminent and unlawful threat of death or grave bodily injury. And then he used the exhibits to illustrate exactly how thoroughly these conditions were met for each and every one of the use of force charges brought against Kyle. Now, Richards did not cover the gun and curfew counts in any depth because, as we noted, Judge Schroeder had not yet determined how or if to instruct the jury on those counts. So Richard stepped through the chronology of events from the first threatening encounter Kyle had with Rosenbaum, during which Rosenbaum had to be held back by others as he attempted to provoke violent confrontation and threatened to murder Kyle if he got him alone, to Rosenbaum's pursuit of an isolated Kyle in the car source parking lot where Kyle would fatally shoot his attacker. Using more photos and videos, Richards illustrated Kyle's desperate flight to the police line down the street to turn himself in, only to be pursued down the street as if by a pack of animals. Struck from behind on the head, his hat knocked off, put down in the street, struck by the flying jump kick of the unidentified man who kicked Kyle in the face with heavy work boots, who Kyle shot at but missed, to the skateboard attack of Huber, who Kyle shot and killed, to the Glock in hand attack by Grosskreutz, who Kyle shot and wounded, all of this occurring in the space of a handful of seconds. He highlighted Kyle's provision of medical care to those who had been injured, his genuine desire to protect the city's private property from riot, looting, and arson, his running with a fire extinguisher to put out what he believed to be another car lot about to be incinerated. Richard noted the substantive involvement in all the chaos that led to these events of Joshua Zeminski, the man who also was armed with a pistol and who fired the shot into the air even as Rosenbaum, apparently his friend, was closing in for the intended deadly attack upon the isolated Rittenhouse. Richards noted that although the state claimed reporter McGinnis as a victim of purported reckless endangerment by Kyle, McGinnis himself would testify that he was never in fear of Kyle, although he was genuinely frightened by some of the genuinely lawless people wandering the streets of Kenosha that night, the very kind of people attacking Kyle. Interestingly, at one point, Richards literally says, quote, "You'll hear testimony, and not just from Kyle Rittenhouse," close quote, suggesting that perhaps the defense intends to have Kyle testify. That said, he didn't explicitly state that the jury would hear from Kyle personally, so it may have been a slip of the tongue, or he may have meant they would hear Kyle's words through one of the many video exhibits. Richards also noted that Kyle never denied his role in any of the shootings and claimed self-defense for his conduct from the very start, including when he turned himself in to the police in his hometown of Antioch, Illinois, within a couple of hours of having survived the deadly attacks upon him. It was, frankly, an overwhelmingly more powerful and effective opening statement than that provided to the jury by the defense, at least in my opinion, but of course you'll be able to judge for yourself. And that brings us to the first witness of the day, the state's witness, Dominic Black. Black was Kyle's friend who had purchased the AR-15 rifle for him and who had accompanied Kyle to Kenosha and the car source lot on the night of August 25th, 2020. Frankly, Black didn't seem to bring much to the table other than perhaps some opportunities for more innuendo from Prosecutor Binger, who conducted the direct examination of Black. For example, Binger repeatedly asked Black if he'd shot anyone that night. If Black had, of course he hadn't, to suggest that therefore it must have been unreasonable for Kyle to have shot people. It's also true, of course, that Black was not faced with an imminent unlawful deadly force attack either, so would not have been justified in shooting anybody. The same can't be said of Kyle. There were a lot of suggestions that the medical gear used by Kyle to provide care that night in Kenosha was actually acquired from Black's home, as if to suggest that the care provided by Kyle was less genuine, or I don't know. There were suggestions that Kyle's possession of the rifle, which was being kept at Black's home in Kenosha, was somehow without Black's permission, although Black had never objected to Kyle's possession of the rifle at any point, and indeed had brought along his own rifle precisely for purposes of personal protection. Both Black and Kyle had earlier in the day met the owners of the Car Source lots and, along with others, had agreed with the owner's permission to provide some security for those lots, one of which had effectively been burned to the ground along with dozens of cars in the previous 2 nights of rioting. But whereas Black had stayed on the roof of one of the Car Source buildings, safe from conflict, a reasonable option, Binger suggested, Kyle had chosen the far more confrontational option of being at street level. Of course, Kyle was there to provide medical aid, and that's hard to do from the roof of a building. Black testified on direct that he didn't see any shooting, didn't see anybody fire a gun, didn't see anybody injured, even though none of this means that Kyle wasn't justified in self-defense in his own circumstances, and Black would later concede that he knew Kyle himself had treated injured people. There also seemed to be some vague attempt by Binger to suggest that Kyle had no legitimate reason for leaving his position near Black's location and traveling to the Car Source lot where he would be attacked by and kill Rosenbaum. The defense narrative is that Kyle had been informed that cars were being set on fire at the second location and ran there with a fire extinguisher. The state's narrative appears to be an effort to suggest that Kyle was in pursuit of a fleeing Rosenbaum, a narrative they seem to think the FBI overhead video footage supports. Black had driven Kyle to the Rittenhouse home in Antioch after the shootings that night, and Binger got Black to talk about how there had been discussions among the Rittenhouse family that perhaps Kyle should flee to family property outside the state. This would prove an innuendo easily exposed by the defense on cross-examination. And that was about it for direct examination of Black by Prosecutor Binger. So then we had the cross-examination of Black by Attorney Richards. And Attorney Richards had Black concede that he was currently being charged with 2 counts for having provided Kyle with the rifle, that each count was good for 6 years if convicted, and that it was Prosecutor Binger himself who had charged and was prosecuting Black. Further, although Black's trial had been set for some months ago, Binger had arranged for the trial to be delayed until after Black had testified against Kyle. He also had Black concede that he certainly hoped Binger would go easy on him in his own case, given his testimony in this trial. And although both Black and the state would deny that any deals had been made, the coercion element present was palpable. On the issue of supposed plans by Kyle to flee to the family property out of state, Richards promptly got Black to concede that those suggestions came solely from Kyle's mother, that Kyle did not agree with them whatever, and that Kyle wanted to and did promptly turn himself into Antioch police. Richards got Black to talk about Kyle providing medical care and putting out fires the night of the shooting, and there was more, of course, to the cross-examination, but nothing very substantial because direct had never been very substantial. And of course, cross-examination is limited to the scope of direct. But again, you'll be able to judge for yourself. Finally, we had the redirect of witness Black by State Prosecutor Binger again. He did a small bit of redirect after the cross-examination, mostly to try to fix the damage caused by Richards having pointed out the coercion present when Binger was also prosecuting Black for felony charges for having provided Kyle with the rifle. And that was it for Black. We next had the second witness, FBI agent Brandon Crayman, who apparently testified about overhead video taken from aerial surveillance. Unfortunately, for unstated reasons, the court declined to broadcast the testimony of Special Agent Crayman, so I've not much to share directly about his testimony. I did learn later that apparently the FBI had possessed both the low-resolution aerial video shared with prosecutors and a high-definition version of the same video. To the outrage of the defense, however, it was discovered today that the high-resolution version of the video had been lost by the agency. Reportedly, even Judge Schroeder was left aghast at the possibility that the FBI had tossed away evidence relevant to a homicide case, but beyond that, I don't have any substantive knowledge of how that all played out. And that brings us to the last witness of the day, which was Corey Washington, also known as Corey Elijah. We really only got through part of the testimony, part of the direct by the state. We'll continue with this witness in the morning. He's described Elijah as a social media influencer. Again, this was in fact only a partial testimony. Basically, Washington described an increasing state of chaos in the city with many out-of-towners and out-of-staters present, many hundreds of people protesting, the police giving up on efforts to maintain public safety, tear gas deployed, people being hit by rubber bullets, roads blocked off with garbage trucks by authorities, and those garbage trucks being set on fire, much other property damage, gasoline bombs thrown into the courthouse, efforts to burn down public buildings, to car source arson lots, and a lot more. Binger spent a lot of time apparently trying to suggest that much of the damage to the city occurred on the 2 nights prior to August 25th, 2020. The suggestion being, I guess, that when Kyle came to Kenosha, it was unnecessary because the worst of the damage was over. Of course, how Kyle was supposed to know that the third night of rioting wouldn't be as bad or worse than the previous 2 nights is not clear to me. Indeed, to the extent that the damage on August 25th was reduced relative to the prior nights, one might argue that it was precisely the presence of armed citizens like Kyle being present that drove that reduction. Binger stepped Washington through some of his live-streamed recordings of the events that night, including video that captured conduct by Rittenhouse and others involved in the events around the shootings. Binger also hit on his repeated theme of, well, nobody else that night was shooting or being injured, as if other people's experiences had anything to do with the reasonableness or not of Kyle's conduct in claimed self-defense. The question here, folks, is not whether other people would have been justified in using deadly force in self-defense, but whether Kyle was. Binger showed quite a bit of video from Washington, but honestly, I don't really see what the point is relevant to the criminal charges or defenses in this trial, except that there appears to be a great deal of chaos, which I would think would benefit the defense in this case. So that brought us to roughly 40 minutes into the direct questioning of Washington by Binger. And it was at that point that the court recessed for the day, with direct to pick up again in the morning on Washington. So that's as good a place as any for us to wrap up our own day's content and analysis on the Rittenhouse trial. Until tomorrow, remember, if you carry a gun so you're hard to kill, that's why I carry a gun. So I'm hard to kill, my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.